Hello all and welcome to another Be Informed session. My name is Carl Buhariwala and today we'll be exploring personal injury matters. Today we'll be having one session which will be recorded and our presenter today is Sach Fernando of Maximum Injury Lawyers, who will be taking us through the rights of the injured at work and also on the road. Today's seminar is being presented in accordance with Australian laws, and the information that's being provided today is of a general nature only and is not specific or tailored to anyone's personal circumstances. So if you do have any questions or any queries in relation to aspects of the seminar being presented by Sach today, please feel free to reach out to him directly. As I have mentioned, the session is being recorded and will be available on our YouTube channel following the conclusion of today's session. There will be Q&A after the seminar being presented by Sach, so please do send through your questions in the chat and I will respond to those by directing them to Sach so that he can provide his comments in response to your questions. We've also received a few questions in advance by email, so we'll be addressing them first before proceeding to the questions raised by the participants in this session. So without any further delay, let's get straight into the session. And Sach, please feel free to commence the seminar now.
Great. Thanks, Carl. Well, thanks for having me at Be Informed to talk about the rights of the injured. My presentation today will focus on the rights of individuals injured at work and on the roads. So we're looking at the Victorian Work Cover Scheme as well as the Transport Accident Commission. Insofar as initiating a claim, if you're injured in work are concerned, if it's a work injury, it's important that an individual submits an incident report to their employer and also following that a work cover claim. A work cover claim typically should be given to the injured worker by the employer, but in the absence of that, that can easily be downloaded from WorkSafe's website. The work cover claim form should be ideally given with a certificate of capacity. And a certificate of capacity is different to a medical certificate. A certificate of capacity will detail what the injured worker's work capacity is, whether they're fit for pre-injury work, whether they're fit only to perform suitable employment, or if they're unfit for any work. It should be reflected in that certificate along with their restrictions. And the employer has to give that work cover claim to their work cover insurer. And the Victorian Work Cover Authority has a panel of work cover insurers who will determine claims like this. And the claims agent will take 28 days to determine whether or not to accept the work cover claim. If the injury happens on the road, the injured individual can easily complete an online claim form through the TAC's website or call the 1300 number. The claim has to be done within 12 months and TAC must make a decision 21 days from when they receive the claim form. Again, we would encourage anyone submitting a claim to include a certificate of capacity so that the TAC can be informed of what the individual's work capacity is. Flowing from an accepted work cover or TAC claim are the rights to income. So, next slide please, Carl. If it's a work injury, an injured worker has an entitlement to a total of 130 weeks of weekly payments. Now, the work cover insurer will calculate the injured worker's pre-injury average weekly earnings. That is calculated based on an average over 12 months of earnings in the 12-month period prior to the work injury. From that average, the individual will get 95% of their pre-injury average weekly earnings, or PRW as we refer to it. And from 13 weeks onwards, they'll get 80%. Payments after 130 weeks is really dependent on the injured worker demonstrating that they've got no work capacity on an indefinite basis. So up until 130 weeks, the legal test is that the injured worker can't do their pre-injury work, and then thereafter they have to demonstrate they can't do any suitable employment on an indefinite basis. So it's a very high threshold, and it looks at the injured individual's physical and psychiatric injuries. When it comes to road injuries, an injured individual will be paid 80% of their pre-injury wage. Again, the same assessment. TAC will get 12 months of earnings prior to the transport accident, work out an average, and from that they'll pay 80% for 18 months. That's called loss of earnings. And then a further period of 18 months called loss of earning capacity. And in order to get the second lot of 18 months, you have to prove that you have no capacity for suitable employment. Whereas the first 18-month period again looks at the ability to perform pre-injury employment. We then have the right to medical expenses. When it comes to medical expenses, next slide, please. Thank you, Carl. WorkSafe can pay for a variety of reasonable and necessary medical expenses. They'll pay for any treatment so long as it's referable to the work injury. Typically, if it's a minor claim, these entitlements will come to an end at 12 months. At 12 months. But more often than not, medical expenses will continue for a very, very long time. So long as doctors say that the need for the treatment is referable to the work injury, it all should be covered. When it comes to the TAC, again, they'll pay for any reasonable costs associated and incurred as a result of the transport accident. It's important to remember the entitlement to medical expenses, it includes things like equipment and aids as well, and domestic assistance, gardening services. So we've seen some creative requests for medical and like expenses being made, for example, equine therapy, dog walkers. So long as there's medical support for the request, it should be approved by the insurers. We then have the right to lump sum entitlements. Now, this is where us lawyers get involved. Our role as injury lawyers is to maximise the entitlements to lump sum compensation. The first lump sum is called an impairment benefit, and an impairment benefit is a modest lump sum that is assessed and that is awarded based on the individual's whole person impairment rating. So whether it's a work injury or a road accident injury, an impairment claim can only be initiated 12 months after the work injury or the road accident. Carl, next slide, please. In order for us to be able to pursue an impairment benefit claim, the doctors who are treating our clients have to confirm that the injuries have stabilized. By that I mean the doctors have confirmed that there is no further treatment that can be done. And even if further treatment is done, it's not going to change the current status of the condition. So long as that opinion is obtained, then an impairment claim can be submitted. With work cover claims, we submit the claim form on the work cover insurer together with supporting medical reports and records. The work cover insurer will then organise a impairment assessment with one of their doctors. Carl, I'm just confirming everyone can still see the slides. From my end, I can't see the slides.
Yes, I'm just having a bit of trouble. I'm trying to figure out why I can't share the slides anymore. But keep on going. I'll try and figure out how to do that.
No problem. So what the work cover insurer will do then is they'll organise one of their doctors to assess our clients. When it comes to upper limbs and lower limbs, the assessment is one of range of movement. The greater the restriction in the range of movement, typically the higher the impairment rating. High the impairment rating, typically high the impairment benefit. So these doctors will do physical assessments of our clients or a psychiatric assessment, and a psychiatric evaluation is done under the GEPIC, a different set of guidelines. And provided that if it's a physical injury, the whole person impairment score that is achieved is 10% or more in a work cover claim, or 30% or more for a psychiatric injury claim, then a lump sum benefit will be awarded. Now, I want to take a moment to discuss psychiatric injury claims because the law makes it almost impossible for someone with a psychiatric injury to be awarded an impairment benefit. There's 6 criteria that an individual is assessed against. That is their intelligence, thought, judgment, perception, mood, and behavior. And an individual will need a category 3 in each of those 6 criteria to get to 30% or more. In my entire 12-year career, I've seen about 5 clients satisfy that threshold. It's extraordinarily high, and you're looking at individuals who are very psychiatrically unwell, paranoid, delusional, on high doses of antidepressant medication, who are suicidal or have attempted suicide, who've undergone ECT treatment, where their cognition and memory is significantly impaired. It is a frustrating threshold for our clients to achieve, and one typically most people don't achieve because it's so high. I recently had a client satisfy the threshold. He was awarded 35%. And that particular client was a chef that had been assaulted at work. And as a result of the assault, he became very paranoid and delusional. He would see images of his former employer, the employer that assaulted him, completely spontaneously, and that would result in him having panic attacks. He had installed cameras at home because of fear that his family may be under attack. He was perceiving cars following him. He would try and avoid any social outings because of his concerns. If he goes into a shopping center, if he sees someone similar that looked like the employer that assaulted him, he would have a panic attack. He was having psychiatric treatment. He was on a cocktail of antidepressant medication. He had been admitted as an inpatient at a psychiatric facility, and he was awarded 35% whole person impairment. Now, TAC is a bit different. With TAC matters, the physical and psychiatric impairments can be combined to achieve the TAC threshold, which is 11%. So work cover is 10%, TAC is 11%. TAC take a much more sensible approach in our view by allowing the combination of both physical and psychiatric injuries. The threshold requirement of 11% is in our experience, it is achievable if someone involved in an accident does have restriction in range of movement, any nerve pain, any loss of sensation, and who have had some psychological treatment prior to us having them examined. The examination is different as well. The examination is called a joint medical examination. That examination is done by a doctor that TAC and our firm will choose. Typically, we would select the doctors and we would make an application to the TAC to approve funding of that joint medical examiner. And so long as that joint medical examiner is accredited under the AMA guides, let me show you guys a copy of the guides. That's how it looks like. So long as that doctor is accredited, then the request for approval will be approved by the TAC. The final slide is in relation to common law damages. Now, this is the favourite part of my job. Common law damages are damages for pain and suffering and economic loss. So long as our clients can demonstrate that the consequences of their injuries, their compensable injuries on their lives are more than considerable or marked, then they should be entitled to claim common law damages. I want to talk you through the process. Firstly, the law says you can't make an application for a serious injury certificate until 18 months has passed since your injury. When we submit an application, we make sure that we prepare an affidavit on our client's behalf that goes into detail about how their accident or their work injury has resulted in serious adverse consequences to their lives. So this is an analysis of the individual before and after the accident or injury, a consideration of their functional limitations, mobility, their sleep, restrictions in their activities of daily living, how it's impacted on their work capacity. So doing that analysis, if we can show that the consequences to the individual from this injury are serious, then they should be awarded a serious injury certificate. In work cover claims, to be entitled to a serious injury certificate for economic loss, you have to demonstrate a permanent 40% loss of earning capacity. Now, that threshold is difficult for some people to achieve, because, especially young people, because if the evidence is that the individual can engage in retraining, then the question turns to what type of work can be done and what sort of earnings can be derived from that sort of profession. Ultimately, if doing that suitable job, our clients are still unable to earn 60% or more of their earning capacity, they may still demonstrate that loss of 40%. Fortunately, the TAC do not have that requirement. In work cover claims, typically work cover will take 120 days to assess a serious injury application. And when we prepare these applications, we make sure that the affidavit is has covered everything, has covered all the consequences, that we've obtained up-to-date medical reports from the doctors that are treating our clients. We make sure that we have up-to-date clinical records so that there can't be any criticism of our clients for not having a well-prepared application or not providing enough information for work cover to make their decision. Work cover after 120 days or 4 months will come to us and say, we're going to offer your client the serious injury certificate for both their pain and suffering and economic loss, or they might say, we're going to offer the serious injury certificate only for pain and suffering because we don't think your client satisfies the economic loss threshold. Now, if that's said to us, we do an analysis of the economic loss. We look at our clients' earnings in the 3-year period prior to the work injury. We get the highest earnings in that 3-year period. We adopt consumer price index increases, or we adopt EBA increases to work out what their earnings would be but for the injury. And then it's an analysis of whether, based on their current limitations and restrictions, they will demonstrate a 40% loss. So for instance, if our client was able to earn $1,000 a week, we have to show that they can't earn more than $600 a week, and that they've lost $400 every week, and that's 40% of the $1,000 they were capable of earning. TAC fortunately doesn't have that requirement. So long as you can show serious consequences, you'll be awarded the certificate. Ultimately, getting a certificate only opens the gateway to claim common law damages. But common law damages will only be awarded if negligence can be proven. In road accidents, it's easier to prove negligence because the accident would typically have been caused by one of the drivers, and typically there'll be a police report that says who's at fault. In work injury cases, it's more tricky, and we have to demonstrate, our clients have to demonstrate that their employer unnecessarily exposed them to a risk of injury, a risk of harm in circumstances where that risk was reasonably foreseeable. That's how you prove that the employer fell short of what a reasonable employer would have done. We look at the systems in place at the time of our client's injury. We'll look at what sort of policies and procedures they had in place, what sort of training and supervision was given, and we form a view as to whether or not negligence can be established. For factory workers, for instance, one of our typical arguments will be that there was no risk assessments of the work duties that our clients performed. Or it may be that our clients were left to their own devices without any sort of supervision, and ultimately, without any guidance, our clients knew to do work the only way they've been shown by their colleagues, and as a result, over time have sustained injury. If agreement can't be reached, we do have to issue a writ, and we have to go to either the county court or Supreme Court. And to prove negligence, we typically defer to expert opinion. Again, in that example, we would turn to the opinion of an engineer, and that engineer would attend the work site, do an analysis of the systems they had, and then provide a report with their opinion as to whether the system of safety was adequate. And if it wasn't adequate, what reasonably practicable alternatives could have been adopted to make this a safer workplace. And ultimately, if that can be established, then our clients will prove negligence. And the question is, how much is their case worth? When it comes to economic loss, it's much easier to assess because it's quite mathematical. So we look, like I said before, look at the financials in the lead up to the accident. We adopt consumer price index increases, EBA percentage increases to work out what the present value of their loss is. For pain and suffering, it's a bit of a lottery. For someone with an operated back, they might get 300,000, they might get 400,000, somewhere in between. Someone who's had an unoperated back might get 150,000 to 200,000, or perhaps a bit more. Ultimately, it all comes down to the consequences on the individual. And that's why we make sure when we prepare our clients' affidavits from the outset that we have very carefully drafted affidavits speaking to the devastating impact of the injury to our client's life. An operated shoulder, for example, might attract 200,000. A total knee replacement might attract around 200, perhaps a bit more. A psychiatric injury might range between 100 to 300,000. So it really comes to the consequences. And the thing is, when a matter goes before a jury, it's very difficult to predict. Your guess is as good as mine. Now, Carl, that's the end of my slides, and I see we're right on 6:25. And you told me 25 minutes.
Thank you, Sach. That was great. Thank you for presenting that seminar on the rights of the injured. I think it's a very topical, sort of topical topic, as pardon the pun, but sort of at this point in time, given we've just come out of COVID, and there are a lot of injuries that might have happened during that period of time, whether it be physical or even sort of emotional or psychological. So a very valid piece of information that you've shared with us today. We will now sort of, yes, such as details are on screen. So if you have any questions, feel free to directly get in contact with him. We'll now progress on to Q&A, which is an opportunity for people on the call today to ask questions. As you're aware, you can submit your questions directly through to me, and then I will share them with Sach. But before we get to those, through the chat, we can ask questions to Sach that we received by email. So Sach, we've received a few questions by email, so we can start with those. Yes, the first one being a very practical question. What should someone do when they are injured? What are some of the first things that they should consider before sort of getting on the bandwagon? They might have had, talking about a workplace, but they've been injured at work. What are some of the first things they should be doing practically?
Lodging that incident report, telling the employer or their manager that they either feel pain or that they've injured themselves. A contemporaneous report of injury is so important. And then they should go and seek some medical advice. Seeing the GP is really important, telling them what happened at work. Telling the GP what sort of work was performed, so the GP can form their preliminary view as to whether this is a work-related injury. In the context of road accidents, again, speaking to a doctor and reporting all areas where you feel pain is important, so that down the track, there can never be a criticism that you didn't complain of the injury. What we often see in our jurisdiction are stoic people, often migrants who've been working in factories all of their lives. They're so stoic that they don't go to a doctor just because they feel a niggle. They would only go to a doctor if the situation is really bad. And the criticism by WorkCover of those individuals is that they never complained. And had they complained to us, the employer, we would have changed the system of work. Well, we know that's not the case. But in any event, it's really important that someone injured files an incident report and goes and gets some medical attention.
Yeah. And just on that, we have another question in relation to how closely does the legal team, so if an injured person were to engage a law firm to assist them with their injury in terms of their rights, how closely do you guys work directly with their medical practitioners? Do you sort of triage the relevant information so that it can come through to you in the right format? How involved is the legal team with their medical team?
So, Carl, we rely heavily on the medical team. In order to progress our clients' lump sum applications, we need up-to-date clinical records and medical reports. So we submit requests to the doctors to obtain their records, and we draft letters of instruction so they can provide a report on the points that we need to progress our clients' lump sum claims. It helps to have good relationships between the medical and legal teams in the event that there are any issues, and that could be, a surgeon requesting surgery and not getting a response from the WorkCover insurer. If we know that a surgery request has gone to the insurer, we'll be diarising within 10 days to follow up whether that's been approved. And if it hasn't been approved, we'd be putting more pressure by requesting conciliation to get a decision made by the insurer. So we try and work closely with the doctors. It depends on the doctor's willingness to engage with us as well. Some doctors don't like lawyers because, well, for obvious reasons. Why don't people like lawyers, Carl? But we try and have healthy relationships so that if there are any issues for our clients, we can reach out to the doctors, let them know what the issue is, obtain the supportive reports that we need to progress our client's claim.
Yeah. And the further question that we've got is in relation to the gig economy. So, we've seen a sort of a rise in the number of individuals participating in the gig economy, taking on sort of contract type, engagements with, whether it be ride sharing or various types of activities within the gig economy. If they are to be injured because they've participated in one activity, how do they then sort of claim loss of earnings when they might have various other activities that they also participate in? How do you sort of quantify that when it's not directly attributable to that activity which they might have suffered? So they might be doing multiple contract work. How does the sort of the assessment of their income sort of work in that case?
Okay, so it's more problematic for those individuals, and it's very important they have their work cover insurance. When it comes to contractors, when it comes to subcontractors, the assessment takes into consideration whether during the 12-month period prior to their injury, whether or not 80% or more of their earnings were derived from one employer. And so if the injury was sustained at that employer's premises, then the work cover claim can be lodged on that employer's work cover insurance. If it's 79% or less, and the injured worker had multiple employers in that 12-month period, then unfortunately work cover will not accept their claim. They will either need to lodge it on their own work cover insurance. If they don't have work cover insurance, they might need to go down the path of income protection.
Yeah. So do you recommend individuals who are in that position obtain their own work cover insurance, especially when they're contracting to various? Yeah. Is it costly in your experience? Sort of what's the sort of amounts that we're looking at for premiums, if you have any sort of experience?
I have no insight into that. The premiums, I understand, is dependent on the revenue. So I would say,
relative,
if there are any contractors here tonight, to make inquiries with one of the work cover insurers, you could probably do a premium calculation through through their website or through the WorkSafe website. But it's worth having your work cover insurance. If you suffer a catastrophic injury and you're in that category, unless you have your own work cover insurance, the situation could be horrendous for you and your family. This is what happens. When someone injures themselves, it doesn't just impact on them, it impacts on their entire family. And the compensation that we fight for, often we know that it's not just for the individual, it's to help their families put this horrible chapter behind and start a new chapter. And that's why
I think it's very important that people in that position sort of consider, because oftentimes you don't think about what happens if you get injured, and you assume that the employer or the person that you're contracting with, will have the funds to be able to remediate what's happened, but often that's not the case. That's why you have the insurance.
No, but also if you look at the contract, if you're in that category and if you have a look at your contract with that particular organization, it probably will say that we're not going to cover you. You've got to have your own insurance.
Definitely. And oftentimes, no one really, of course, we all as lawyers recommend individuals to get their contracts reviewed. But I think when people are in the thick of the moment and wish to get that job and see an income stream, they often don't look at those terms in great detail, and will take whatever they can get. So definitely wise words to really consider that, especially when you're working in activities that are sort of more high risk, like ride sharing and the like. And our final written question that's come through to us by email before the session today is around affidavits, and what level of detail sort of needs to go into those. Of course, lawyers will assist in drafting those and sort of putting together the relevant information. But when they're sort of considering the information that needs to be presented to allow the individual to sort of explain, how the injury has impacted on their life and on their sort of future outlook, what sort of things should be front of mind for those individuals?
So affidavits, we typically counsel to draft them because there is strategy behind an affidavit, and you don't put too much. You shouldn't be putting too little. You need to, in the affidavits for serious injury applications, there should be essentially a clear picture of the individual's life pre-injury and how it's been adversely impacted post-injury. Affidavits should avoid using definitive words like never. That's because if a client of ours says, I never go fishing, and down the track before their court case, Work Cover commissions a surveillance company to surveillance them, and they find that our client on one occasion has gone fishing with some friends who might have said to him, mate, let's get out of the house. You've been very depressed. Let's just get you out and let's do something you used to enjoy. Even if it was for that purpose, if they had said, I never do any fishing, and that's seen, well, that completely discredits them.
Yeah, so it needs to basically reflect, to be a factually accurate sort of representation of what they've been doing and what they wish to do, isn't it? It's not trying to sort of suggest anything hopeful or anything sort of exaggerated. It's a factually accurate representation of the circumstances.
That's right, Carl. It's got to be realistic, accurate, and not exaggerated, because if clients exaggerating their affidavits and there is surveillance, then it can discredit them and throw their entire case out.
Yeah.
Sadly.
Have you seen that in your experience, sort of seeing this favorably?
Oh yeah. I mean, we had a situation recently, and our client is a genuine, lovely person who has suffered with a chronic back condition. He's in his early 40s, and he slipped and injured himself in a staircase at work because the steps were very slippery and didn't have any non-slip treading. He, as a result, suffered tremendously. He, in his affidavit, indicated he does go fishing from time to time. He didn't say he doesn't, he'll do it at all. But the presentation of him in the surveillance that was adduced at court showed him more mobile than how he presented to doctors, and doctors that gave reports that support him. So we had supportive reports from doctors to say he is incapacitated for employment. He'll never work again because of this debilitating chronic back condition. But the judge couldn't accept our client's evidence of his disability or the supportive doctors who concluded he had no work capacity or spoke to how bad his back condition was, because the way he presented on film was different. Now, our client's explanation was that when he went fishing, he actually took lots of pain medication so that he could enjoy that to some extent, as he used to before injury. And the example I gave, I was thinking of him. His mate said to him, we've got to get you out of the house, let's get you fishing. But whatever the explanation was, it was open to a court to find that the presentation was inconsistent and to discredit him and to not accept his version of disability.
Yeah. So I think that's quite sort of important to remember that, I think exaggeration and sort of inflationary type, wording used in those affidavits or in the evidence might not be in the best interest of the injured.
Words like don't, never, can't. Instead, replace it with I have great difficulty.
Right. There we are. That's good to know. All right. Well, I'm going to thank some of the individuals that have sent through some sort of questions through the chat through to me. So we'll just go through them. There are not too many such. So, this might be a short session on this occasion.
Sure.
The first one being in relation to the right to income. Is that a sort of is that rule that's being set sort of standard across all of Australia, or is that a sort of a state-by-state based regime?
I can only comment on Victoria, Carl, because that's my area of expertise. But from my understanding of the schemes across the state, and unfortunately they're all very different. There's some similarities between Victoria, Tasmania and Queensland, and as I understand, every state should have an entitlement to the right to income and medical expenses. They are what's called statutory entitlements, entitlements that an injured individual should have if they've injured themselves at work, regardless of whose fault the injury was. If, for example, now we didn't cover in this presentation medical negligence or public liability, or general insurance, that if an injury happened as a result of a product defect or as a result of a slip and trip at a shopping centre or medical negligence, there is no statutory scheme. And so there's no right to income in those insurance schemes. But work cover in Victoria and TAC both have the right to income. And medical expenses.
No, that's perfect. Yeah, this is just a reminder that this sort of seminar is based on Victorian law, given this is the sort of jurisdiction that we are all participating in today, especially our presenter. All right, so our next question is just in relation to the policies and procedures of an employer. So, you know, you might be having an incident where, you know, if I understand this question correctly, where there's been an injury at work. To what extent do the policies and procedures of the employer sort of take any sort of relevance in the assessment of the injured party's injury? So, for example, and I think this question is probably coming from an individual who might be running a business, and that individual is asking, well, if we've told individuals, i.e. the employees, to not do certain things or to act in a particular way, how can that sort of support any claim that the injured party is making?
Good question. The policies and procedures are incredibly important, and they become relevant when it comes to with the injured worker's entitlement to common law damages.
Right.
Doesn't make much of a difference as to the acceptance of their claims. Like I said, in Victoria, it's a no-fault jurisdiction, which means that ultimately, if it's proven that the injury happened at work, then they're entitled to the claim being accepted, even if that injury was an injury that they caused. So policies and procedures are looked at closely when we pursue common law damages, because if, for example, that very example you talked about, a worker going and acting contrary to policies and procedures, well, that can mean a reduction of their entitlement to common law damages. If the policies say you've got to do it in a certain way and the injured worker was doing it in a contrary way, they weren't following proper direction, proper policies of the employer, and therefore there would be a reduction of their damages for contributory negligence.
Right. So contributory negligence definitely plays a part in assessing quantum of damages.
Oh, it absolutely does. But it still, I mean, it might reduce, but it doesn't mean that they're not entitled to any damages. I mean, you can't just have policies and procedures and wipe your hands clean. Just because they're there doesn't mean an employer does nothing. You need a combination of policies and procedures, proper supervision, management that enforces those policies and procedures to ensure that workers are adhering to the policies and procedures. So in that situation where even if the injured worker was acting contrary to the policies, if that injured worker wasn't supervised adequately and hadn't been for an extended period of time and was doing it the only way he or she knew how to do it, their negligence against the employer will be proven for inadequate supervision. But then the damages will be reduced for the injured individual doing something in a contrary way. Yeah,
they're very important. Our next question is on medical expenses for those that have pre-existing medical conditions, and then the injury exacerbates their medical circumstances. How is that sort of all assessed in the right to, you know, claiming for medical expenses? Is that an important factor? I would assume so.
Yeah, it is an important factor. But at the same time, in a work injury context, if the work duties or incident that took place at work resulting in injury can be shown to have been a significant contributing factor, then the entitlement to compensation follows.
Yeah.
So it doesn't matter if the injured individual had a pre-existing condition, so long as employment was a significant contributing factor to their injuries, in the sense that it either aggravated, accelerated, exacerbated, caused a recurrence, caused a deterioration of a pre-existing injury or illness, then the injury is compensable.
Yeah. And our final question, and I'll just do another call out to anyone that wants to submit any final question, but our final question is in relation to TAC claims. Do we need to engage a lawyer, or can they do it on their own? What are your thoughts on that?
To lodge a claim in a TAC claim, it's very easy. You can do it online. But to pursue a common law claim or to pursue an impairment benefits claim, it's important you have a lawyer, and not just any lawyer, someone that specializes in injury law. And that's because if you're unrepresented, this is still an insurance scheme. Insurance schemes try and protect every dollar. The purpose of having lawyers is that lawyers will advocate to get the most amount of money for you. And often anyone good in this jurisdiction will work on a no-win, no-fee basis. And you shouldn't be out of pocket for anything. So there should be very little financial risk to an individual in engaging legal representation. Of course, even with that said, it's important for the individual to understand how that law firm's costs work, whether they fix fees, cap fees, charge by the hour. But once that assessment is done, you should be able to find a lawyer who knows what they're doing and is very reasonable. And I would hope that's what my firm, Maxium Injury Lawyers, is about. We charge fairly and reasonably for the work that we do, but over the life of the claim, our clients don't need to pay anything. And we're very passionate about what we do, and we've chosen to specialize exclusively in injury compensation because we know that insurance schemes tend to really take advantage of people who are unrepresented. And our role is to try and advocate to get the most amount of money so that we can give closure to our clients and they can move on. Yeah. That's what money does for people, Carl. Like, it doesn't make them feel better. It doesn't make people's health better.
Yeah.
What we do as lawyers is very confined, and it's confined to getting our clients the most amount of money so that they have some financial security and they can put this behind them.
That's perfect. No, thank you, Sach. And I'll just bring up Sach's details again on screen. So thank you to Sach Fernando of Maxium Injury Lawyers for presenting this seminar and the session today. So today is just a single session, as you're aware. His details are on screen. So if you have any sort of queries that you would like to raise, please feel free to contact him directly. And that brings us to the end of our session. So thank you all for attending. This session has been recorded, as you're aware, so a copy of the recording will be available on our YouTube channel, so you can feel free to share that with family and friends. This session sort of brings us towards the end of the year as well, so sessions will continue in the new year, and I'll be sharing the one-page handout as well that Sach has prepared, which sort of contains a very short summary of the matter of the materials that have been addressed today, and his details are also included on that one-page handout. So if you have any additional questions, you can always contact him and his firm. Yeah, I'll be sending out a quick survey link as well to those that have participated. So I'm keen to get your feedback on anything that we can do better. And I think that brings us to the end. So once again, thank you, Sach, and wishing everyone a sort of a Merry Christmas and a Happy New Year, and we'll see everyone on the other side.
Thank you, Carl, and thanks for everyone who attended. I wish you all a very Merry Christmas and Happy New Year.
Perfect. Thanks, Sach.
Take care, guys. Bye.
Yeah, bye.